Hello everyone, welcome to your lordships. Welcome to your lordships revised through MCQ series. So today we are going to discuss another 20 questions of the Indian Evidence Act or the Bharatiya Sakshya Adhiniyam. So let's start with the first question, and the first question is the relevancy of facts forming a part of the same transaction under section 6 of the Indian Evidence Act 1872 is known as. This question has been asked in Gujarat Judiciary 2019. There are four options: res ipsa loquitur, res judicata, res sub judice, res juste. Now let's see the answer. Answer is it is res juste. And where is it given? It is given under section 6 of Indian Evidence Act. Now the same has been renumbered as section 4 of Bharatiya Sakshya Adhiniyam, that facts forming part of same transaction, which is in English law it is called doctrine of res juste. Next question is, section 7 of Indian Evidence Act does not include which one of the following? This question has been asked in UP Judiciary. Now options are occasion, cause, purpose, effect. Let's see the answer. It is purpose. So if you have to see the explanation, the section 7, which is now the section 5 of BSA, it says facts which are the occasion, cause or effect of fact in issue. So facts which are occasion, cause and effect. So purpose is not mentioned over there. So answer is purpose. Third question is, under section 8 of Indian Evidence Act, it has been asked in Uttarakhand Judicial Services, motive is relevant, preparation is relevant, conduct is relevant, all of the above. Let's see the answer. Now answer is all of the above. So under section 8, all the three, motive, preparation and conduct, all are relevant, and it is given in this section. Section 8, any fact is relevant which shows or constitute motive or preparation for any fact in issue or the relevant fact, the conduct of any party, or it is the you can see any fact relevant which shows or constitute motive or preparation for any fact in issue or the relevant fact, and the conduct. So all the three are mentioned over here. Now the same has been renumbered as section 6. Next question is, A is tried for the murder of B by poison. The fact that before the death of B, A procured poison similar to that which was administered to B is. Now this question has been asked in MP Judiciary, in Haryana Judicial Services. Options are not relevant, relevant, partly relevant, neither relevant nor irrelevant. Let's see the answer. It is relevant. Where is it given? It is given under section 8. If you'll see the illustration C of section 8, it says the same thing. A is tried for the murder of B by poison. The fact that before the death of B, A procured poison similar to that which was administered to B is relevant. Now section 8 has been renumbered as section 6 of BSA. Next question is, identification of accused person is related to which of the following section of Indian Evidence Act? This question has been asked in Uttarakhand Judicial Services, whether it is relevant under section 6, under section 9, under section 11 or 21. Identification of the accused person. So this is a very general question, normally it is asked. So the answer is section 9, section 9 of Indian Evidence Act. So it says facts necessary to explain or introduce a fact in issue or a relevant fact which supports or rebuts inferences suggested by a fact in issue or relevant fact, or which establishes the identity of a thing or person whose identity is relevant. So the correct answer is section 9. The same has been renumbered as section 7. The next question is, A and B were prosecuted for conspiracy for bribing a police officer. A came to the police station and offered an inspector a packet of currency notes. He told that inspector told B had sent the money as a consideration for hushing up the case against him. The offer of money and the accompanying statement made by A were relevant against. This question has been asked in DJS. A only, B only, both A and B, none of the above. See the answer, both A and B. So this is the offer of money and the accompanying statement made by A were relevant against both A and B. Where is it given? So this is relevant as per things said or done by conspirator in reference to a common design, section 10 of Indian Evidence Act. The offer of bribe and A's statement are relevant against A and B under section 10 of the Indian Evidence Act, as they were made in reference to the common intention of the conspiracy. So now the same has been renumbered as section 8 of the Bharatiya Sakshya Adhiniyam. Next question is, under which provision of the Indian Evidence Act an accused may plead alibi? So this question has been asked in RJS, that is Rajasthan Judiciary, section 10, 11, 12 or 13. Let's see the answer. Answer is section 11. So section 11 is related to your plea of alibi. So this is directly given in the heading, that is when the person claims that he was elsewhere. Next question is, the case Dudhnath Pandey versus State of UP is related to. It has been asked in UP Judiciary, Uttarakhand Judiciary as well. So this is related to res juste, plea of alibi, admission or accomplish. The answer is, it is related to plea of alibi. Dudhnath Pandey versus State of Uttar Pradesh, 1981 Supreme Court. Next question is, X sues Y for damage done by a dog of Y, which Y knew to be ferocious, the fact that the dog had previously bitten A, B and C are. This has been asked in UP Judicial Services. Relevant, irrelevant, inadmissible, unreliable. See the answer? It is very much relevant. Where is it given? It is given under section 14 of Indian Evidence Act. The same has been renumbered as section 12 of Bharatiya Sakshya Adhiniyam. The case is similar to the illustration C of section 14 of the Indian Evidence Act. Y's prior knowledge of his dog's dangerous nature, evident by previous instances of the dog biting A, B and C, is relevant under section 14 to prove the Y's awareness and intent, making his liability more probable. So section 14 is the answer. Next question is, under Indian Evidence Act 1872, which one of the following section defines admission? This has been asked again in UP Judiciary. Section 17, 18, 19, 20. Let's see the answer. It is section 17 that defines admission. See, these are very simple section based questions which fetches 2 or 1.5 marks or 1 marks in prelims. Now this is section 17 that defines admission is a statement. Now the same has been renumbered as section 15 of Bharatiya Sakshya Adhiniyam. The next question is, who can make an admission under Indian Evidence Act? Again, this has been asked in Uttarakhand Judicial Services, which is again now going to be conducted. Witness to a proceeding, party to a proceeding, a third party, the court. So who can make admissions? A party to the proceeding can make admission. Now this is given again under section 18 of Indian Evidence Act, that who can make admissions. So here it is given under section 18 that a party to the proceeding can make admission. The next question is that a confession even consists of conversation of oneself, for it is not necessary for the relevance of confession that it should be communicated of some other person. It was held in which case? It has been asked in 2018 UP Judiciary Exam, 2022 Judiciary Exam, Shankaria versus State of Rajasthan, Bhuta Singh versus State of Punjab, Sahu versus State of UP, 𝐒𝐔𝐁𝐄 versus State of Bihar. Let's see the answer. It is Sahu versus State of UP, that is option C. Explanation is Sahu versus State of UP 1966. It clearly says Supreme Court held a confession need not be communicated to any other person. It can even be made to oneself. So answer is that a confession can be made to the person himself. Next question is, confession of a co-accused not required to be taken on oath and cannot be tested by cross-examination. Statement 1. Is no evidence within the meaning of section 3 of Evidence Act and cannot be foundation of a conviction. The only limited use which can be made of a confession of a co-accused is by way of furnishing an additional reason for believing such other evidences as exist. It is very weak type of evidence and is much weaker even than the evidence of an approver. In the aforesaid proposition, this question has been asked in Odisha Judicial Services. All 1, 2 and 3 are correct, only 1 and 3 are correct, only 1 and 2 are correct, only 2 and 3 are correct. Let's see the answer. All 1, 2 and 3 are correct. So this is the Explanation: because in Kashmir Singh versus State of Madhya Pradesh, it is said by the Supreme Court that Indian Evidence Act cannot be the sole basis of a conviction. So, confession under section 30, that is of co-accused, cannot be the sole basis of the conviction, and it says it can only be used to support other independent evidence and is considered weaker than the testimony of an approver. Next question: during the course of trial of a murder case, which one of the following may be proved? This has been asked in RJS. Again, RJS is going to be conducted very soon. A statement of confession of accused made in police custody during investigation, recovery of the weapon of offence on the basis of the statement made by accused during the investigation of another case. After recovery of dead body, the statement of accused as to the place where he threw the dead body, none of the above. So, basically these are 4 options. During the course of a trial of murder case, which of the following may be proved? Now, see the answer. Answer is recovery of the weapon of an offence on the basis of the statement made by accused during the investigation of another case. And the explanation lies in section 27 of Indian Evidence Act, which has now been renumbered as 23 clause 2, where it says, provided that when any fact is deposed as to discovered in consequence of information received from the person accused of any offence in the custody of the police officer, so much of such information, whether it amounts to confession or not, as relates distinctly to the fact thereby discovered, may be proved. So, the answer lies in section 27 or 23 clause 2 of Bharatiya Sakshya Niyam. The next question is, in which of the following cases it was held that section 27 of Indian Evidence Act is an exception to section 24, 25 and 26? This has been asked multiple times in UP Judiciary, Uttarakhand Judiciary. Now, see the options: Pakla Narayan Swamy versus King Emperor, Inayatullah versus State of Maharashtra, Muhammad Inayatullah versus State of Maharashtra, State of UP versus Devman Upadhyay, or Kotaiya versus King Emperor. Let us see the answer. It is State of UP versus Devman Upadhyay. So, State of UP versus Devman Upadhyay, 1960 Supreme Court, where Supreme Court clarified that section 27 of Indian Evidence Act is an exception not only to 26 but also to 24 and 25. Now, we are going to discuss the proposed questions on BSA, that is Bharatiya Sakshya Niyam, which might be asked in the upcoming examinations. So, the question is whether goods ordered from B were delivered to A, the goods passed through several intermediaries under BSA. Which one of the following is true? Only the final delivery of A is relevant, only the first delivery from B is relevant, each intermediate delivery is a relevant fact, delivery details are not relevant in this case. Option is each intermediary's delivery is relevant. So, where is it given? This is given under section 4 of BSA. The illustration D of section 4 of BSA, the question is whether certain goods ordered from B were delivered to A. The goods were delivered to several intermediaries persons successively, each delivery is relevant fact. So, this is directly based on the illustrations which is given in this section. The question is whether A committed a crime at Chennai on a certain day. It is found that A was at Ladakh around the same day. Which of the following statement is correct as per BSA 2023? A's presence at Ladakh is irrelevant unless proved by eyewitnesses. A's presence at Ladakh is irrelevant if he was not arrested there. A's presence at Ladakh is relevant as it makes the commission of the crime improbable. A's presence at Ladakh is relevant only if the crime was committed at night. See the answer, A's presence at Ladakh is relevant as it makes the commission of the crime improbable. So, where is the explanation? It is in section 9 of the Bharatiya Sakshya Niyam, which is directly related to illustration A, whether A committed a crime at Chennai on a certain day, the fact that on that day A was in Ladakh is relevant. So, this is directly on the illustration given in section 9 of Bharatiya Sakshya Niyam. The next question is whether which section of the BSA 2023 deals with the fact showing existence of a state of mind or the body or bodily feeling. Options are section 10, 11, 12 or 13. Let us see the answer. It is section 12 of Bharatiya Sakshya Niyam. And section 12 talks about a state of mind, body or bodily feeling. The next question is, which of the following section of BSA 2023 prescribes conditions for making oral admissions as to the contents of documents as relevant. Section 22, 21, 20, 19. Answer is section 20 of the Bharatiya Sakshya Niyam. It prescribes the condition for making oral admissions as to the contents of documents are relevant. So this is given in section 20 of the Bharatiya Sakshya Niyam. Oral admissions as to contents of documents are not relevant unless and until the party proposing to prove them showing that he is entitled to give secondary evidence. The next question is, a dying declaration to be admissible. Options: must be made before a magistrate, must be made before a police officer, must be made before a doctor or a private person, may be made either before a magistrate or a police officer or a doctor or a private person. The answer is may be made either before a magistrate or a police officer or a doctor or a private person, and the answer lies in section 26 of the Bharatiya Sakshya Niyam that talks about cases in which a statement of relevant fact by a person who is dead or cannot be found, etc. is relevant. So this is clearly given that it can be made to any person when the statement is made by a person as to the cause of his death or to any of the circumstances or the transaction which resulted into in death, in the cases which caused to that person's death comes into question. Such statements are relevant whether the person who made them was or was not at the time they were made under expectation of death, and whatever may be the nature of the proceeding in which the cause of his death comes into question. So there is no such condition given that to whom this is to be made. Only condition is that the statement should be made. So these are the important questions which are asked in your examination, which might be asked in your coming examination, and for any kind of query or a question, you can visit our website yourlordships.in, and for more query kindly subscribe our channel Your Lordships. Thank you so much.